Uh, Hello everyone. Hello and good evening. I hope you're all well. I hope you had a great Diwali, and I hope you got your break for almost 6 7 days. And now that your break is over, I think it's about time for you to go back into preparation mode. Okay. Not a lot of time is left for your CLAT paper. So obviously now you have to pull up your socks and make sure that in the next 6 months, if you have made mistakes and you're aware of the mistakes that you've made, then definitely work on them. If you have been doing well, then maybe improve. But in any case, be dead serious about the CLAT paper, especially people who also have their boards now. I'm being told that ISC and CBSE students will soon have the first part of their board examinations, which sounds a bit crazy, but then there it is in some days from now. So all the best for that as well. And I hope you secure good marks in the first step of the board examination. Now, in today's session, guys, we will be discussing the CLAT paper of 2020, the legal reasoning section of the CLAT 2020 paper. And guys, I just give me 1 second. I think there is some technical glitch here. Just give me 1 second. All right, sorry. There was some technical glitch, but I think my video all of a sudden started buffering, but it's all right now. All right, so we'll move on to the CLAT 2020 paper, the legal reasoning section, guys. And before I begin with the discussion of the paper, there are a few things that I wanted to say about the CLAT 2020 paper, and especially a few things about the legal reasoning section. So the CLAT 2020 paper was obviously the first paper after they announced the change in the pattern. And it was a brilliant paper. I mean, if you ask me, historically speaking, this was one of my favorite CLAT papers. And definitely the legal section was a very different section. It was a very creative section. It was a very welcome change. From the questions that you'd gotten in the previous few years where the level or the standard of questions had dropped pretty terribly and I mean, baby questions. So I think the entire problem with the CLAT paper for the longest time has been that there were papers which were controversial, there were papers which were really difficult. So towards the end, before the new change in the syllabus was announced, I think the CLAT paper or the CLAT committee basically started to play it safe or something. I mean, let's not invite any problem and let's make a very simple paper, a very standard simple paper with very easy questions, without any controversy, without a higher difficulty level, so that we are able to tread in smooth waters. But I think that is not an ideal thing to do, in the sense that when you make a paper which is very easy, then what happens is that everybody loses their edge. Let's say I worked really hard for the English section and somebody just prepared for 15 days. But at the end of the day, if you have a question which says that what do you put before an apple, a apple or an apple, then everybody is going to answer that question. Everybody will be able to answer that question. And so I lose my edge. The entire effort that basically I had put in for the past 1 year, it goes down the drain in a way. It does go down the drain because everybody would be able to answer the paper. And then luck plays a very important role. Luck starts playing a very important role. There are people who really worked hard, and when they saw that the paper is actually so easy, they got nervous right in the middle of the paper. They really got nervous that, everybody, the cutoffs are going to skyrocket, and I don't think I'm going to make it, and I think everybody else is going to be able to answer these questions as well. And they have to pay the cost for it. So, when the new pattern was, so this was how the old CLAT pattern ended, with me feeling that obviously luck played a big role and a lot of obviously talented students did make, but a lot of students who worked really hard couldn't really make it because of the easiness of the paper, to say so. So when the change in the pattern was announced, I was really happy. But then again, with a pinch of salt, I took the decision with a pinch of salt because given the history of the clats, I was like, let's see what happens. But after seeing the first paper, I was so impressed. I mean, I wasn't really, to be very frank and to be very honest, so impressed with the 2021 paper. But with 2020 paper, especially the legal section, really happy, really impressed. A very refreshing section. All the passages that had come from, be it the sample papers, be it the passages, the topics were pretty much the same. You had questions from contract and criminal and tort and consti law, but then all these passages were based on some current contemporary burning legal topic. So I'm sure everybody must have already seen the CLAT 2020 paper as well. You see, all these passages were based on some current topic. So you had questions on the first question that I'm going to be starting with in today's class. The question was on the force majeure clause, the act of God clause. Because of the pandemic, what is happening. There are so many people who are not paying their rents. There are so many employers who are not paying their employees. And in a way, they're breaching the contracts. And the reason that they're citing is act of God or force majeure. Then the passage that we had on tort law, which is the next passage that I'm going to be discussing in today's class, that was on absolute and strict liability. I hope all of you remember right at the beginning of the pandemic, I think 4 or 5 months into the lockdown, there was this gas leak at the LG polymer factory in Vishakhapatnam. So the passage on absolute and strict liability was based on the gas leak that took place in Vishakhapatnam. So I was really impressed with the paper, and I was hoping that the same thing would be repeated in 2021. Now this is something with the CLAT paper that is, how do I put it? I really don't want to use the word disappointing, but I'm not really finding another word for it. It is actually a bit disappointing. Like there is no consistency in the paper. And I mean, surprises are good for a competitive exam, but then these surprises in the CLAT paper are a bit unwelcoming in the sense that the 2020 paper had all the legal passages based on some current topic. And so, what is the message that the next year's participant will take? That if you're preparing for legal, then in consti law, we need to focus on topics which are currently in the news. In tort law, again, we need to take up topics like vicarious liability. All right, has something happened in the world of law in relation to vicarious liability for the past 1 year or the past couple of years? Let me focus on that. So everybody started preparing the most important judgments and see what areas of consti, contract, tort, and other miscellaneous areas were involved. But then you have the CLAT 2021 paper, which again, is a very traditional orthodox paper. I don't think any of the passages had to do with any current legal happening. They were traditional passages on res judicata and, you know, compassionate appointment and communication of offers and acceptances and undue influence and fraud in contract law and voluntary non-fit injuria in tort law. So very traditional passages again. So which is why again like students actually had prepared a lot of contemporary topics in constate tort contract because of what the CLAT 2020 paper had actually asked. Okay, so again, enough with the banter, enough with the rant about the CLAT paper. I think if I start ranting about the CLAT paper, it's gonna take. I need a separate YouTube series for that. Okay, again, not that it's a very symbiotic, it's a very love-hate relationship between, I think, teachers who teach students for the CLAT and the consortium. You love them for certain things, you don't love them for certain things. But it's a free country. I think everybody is allowed to speak their mind. Okay. The only one message, however, I mean, before I start the discussion of the paper, the only one message that I have for all the aspirants, guys, is that you should never base your CLAT preparation on the latest trend of the paper. You will, in all probability, you will end up paying a very heavy cost for it. A very heavy cost for it. And I've seen this a number of times that people kind of base their CLAT preparation on the basis of the latest CLAT paper. Like, for example, they will see that, in the logic section, the first paper on the new syllabus had very few analytical reasoning questions. The next paper had almost no analytical reasoning questions. So I think CR is what we have to do, and let's just forget about AR. Well, you never know, guys. You never know, the next year's paper might have 5 questions or even 10 questions on analytical reasoning, you know. So that's the thing about the CLAT paper. You should never base your preparation on the last year's trend. Last year, if you look at the CLAT 2021 paper, there were 3 passages on contract, one passage on, civil procedure code, one passage on Hindu law, family law, one passage on criminal law, one passage on service law, compassionate appointment, and one passage on VNFI, which is tort law. Now, there was not any passage on constitutional law, and you had 3 passages on contract law. Now, what is the mistake that some of the students will end up making? The one mistake that some of the students will end up making is, okay, so contract law is most important because there were 3 passages on contract law, and consti law maybe is not very important because any passage, there was no passage on consti law. Do not do that, guys, okay? A very, very strong piece of advice. Do not do that. For all you know, the next year paper might give you 3 passages on consti law and maybe 0 passage on contract law, just 1 passage on contract law. All right. So do not take these decisions, without consulting, and just not take the decision. Like, you don't even need to consult. You just have to make sure that you pay equal focus on all the different areas of law, because what the paper is going to bring to you, you never know that. And especially with the CLAT exam. All right. With that, guys, we will start with the discussion of the paper. Okay, with that, I'm going to just start with the discussion of the CLAT 2020 paper. And the first thing that I'm going to take is the first passage itself. Okay, now I hope you have a copy of the CLAT paper. If you're attending this session of mine, then I would request that on your laptop or on your mobile, from wherever you're accessing my session, maybe just open one copy of the CLAT 2021 paper. And in a live class, I would have given you some time to read, but since this is a live YouTube session, I'm sorry, I don't really have the luxury to give you the time to read the passage. But I'm assuming that majority of the people who are preparing for the paper have already kind of read the passage, or at least have some idea about the passage. Okay, so I'm going to start with the first passage. So this is the first passage, and I hope that some of you would have already read the passage, at least if not read, have some idea about the passage. So in brief, I am just gonna summarize the passage for you. Okay, I will be summarizing the passage for you. So the passage, basically, like I said, most of the passages in this year's paper, 2020 paper, were based on some current legal happening. Now, current legal happening during the pandemic in the world of contract law was definitely people breaching contracts, because they cited that we don't have the power to pay, we don't have the means to pay because of act of God, because of force majeure, because of the pandemic. Now, the rule of force majeure or act of God is a very simple rule, guys. I mean, a contract does become frustrated, a contract does become void if obviously it becomes impossible to perform the contract because of some event, because of some, a natural calamity, or as we call it, an act of God. Okay. Now, when you get questions on force majeure and act of God, guys, before we dwell deeper into the passage, let's say that A and B enter into a contract. Okay. Now, to give you a basic example of when act of God applies to a question, let's say A and B enter into a contract, and A is supposed to do something for B and B is supposed to pay him the money. B pays him the advance money, but when it comes for A to perform his part of the obligation, let's say there's a massive earthquake in the city and the whole city is destroyed, and it's obviously impossible for anybody to come outside of their house and do their daily job. So here, the act of God is the natural calamity, which is the earthquake. Okay. And therefore, the contract in a way will become void because it is impossible for the first party now to perform his part of the obligation. So this is a very standard example of act of God. But let's now twist this question a little bit. Okay, so let's say that A is a homeowner and B is a constructor. All right. Now, A buys a house from B. B in the contract says that this house is well built and blah, blah, blah and everything. And this is the cost price. You need to pay the money and you can have the possession of the house. Now, B takes that house, or let's say A takes that house. One day there is a rainfall, and because of the shoddy construction, the ceiling of the house collapses. as a result of which, let's say this guy A is injured. So now he brings a case of breach in contract against the constructor, saying that he promised good construction, but this is absolutely shoddy construction. And now the constructor says that I am not at fault because the ceiling collapsed as a result of the rainfall. And rainfall is not man-made. Rainfall is not something that, I kind of induced. It's a natural phenomena. It's an act of God. So the question here is that will this constructor be allowed to invoke the act of God or the force majeure clause in a question like this? And the answer to the question, guys, is absolutely not. All right. And why? Because what you need to understand about act of God is that it will only be applicable to calamities or phenomena which are unforeseeable in nature. Okay. Kind of unprecedented and unforeseeable. So unforeseeable is the catchword here. All right. Unforeseeable is the catchword here. Now, a regular rainfall on a given day, is it something which is foreseeable or unforeseeable? I think everybody would agree that it's definitely something which is foreseeable. And since it's a natural phenomena which is very much foreseeable, the act of God clause will not be invoked in such cases of breach. But yes, in the last question, when we were talking about the earthquake that destroyed the entire city, well, do you wake up and kind of, and don't tell me things like, sir, होने को तो कुछ भी हो सकता है, ऐसे तो फिर कभी कोई question ही नहीं solve होगा. All right. So let's apply some reasonability and basic common sense here in these questions. You don't wake up thinking that, the world is going to come to an end or there is going to be an apocalypse and there's going to be a crazy earthquake where everything in the city will be destroyed and millions of people are going to die. You don't wake up with that thought. But do you wake up with the thought that it might rain today? Of course, yes. Okay. So in the last question, the unprecedented earthquake that destroyed the city, well, of course, that is something which is unforeseeable, but a regular rainfall on a given day will definitely not come under the bracket of unforeseeable, and which is why the act of God defense is not going to be invoked. Okay. So this was a bit about the act of God defense. This passage is also about the difference between the material adverse change. So this is the point here, guys. Material adverse change and act of God. Okay. Sorry. So the passage here, if you come to the beginning of the passage, it describes the whole act of God phenomena. And along with that, it also talks about the material adverse effect phenomena. And an important point in the passage is the distinction between the two. The distinction between act of God and material adverse effect. Okay. Now, when we come to the distinction between the two, guys, let us try to understand what it is. Okay. Now, act of God and material adverse effect, guys, act of God is applicable to a contract once the obligations or once the performance of the contract has already started. Okay. Once the contract is ongoing and once the performance of the contract has already started, then act of God comes into play, as opposed to material adverse effect, which is material adverse effect comes into play where the performance or the fulfillment of the obligations under the contract have yet not started and the contract is still in the initial stages where two parties have signed the contract, two parties have signed that there would be a contract in the future. There are, dependent on multiple factors like dialogues and debates and so on and so forth. Like, for example, if we talk about mergers and acquisitions, okay? When we talk about mergers and acquisitions, let's say one party decides to acquire another company. Now it's a very long process. It's not a process where two people are going to meet and sign the contract and from the next day, A company is going to acquire B company. The dialogues will start. There will be some signing of the paper because obviously nobody in the commercial world wants to waste their time. So there's going to be some undertaking, some signing that both the parties are going to do, showing their intent to merge the businesses or showing their intent to buy/sell the company. But the dialogues are going to continue. And then ultimately there'll be a day when the dialogues will be over and now the performance phase, okay, or the adaptation phase will start. Now here, material adverse effect will come into play while after signing the contract, the performances have not yet begun. the fulfillment of the obligations have not yet begun, and if something happens, some event happens that kind of changes the entire contract or the fulfillment of obligations, that has a very imperative impact, that has a very strong impact, that has a adverse, positive, negative impact, whatever, on the beginning, on the starting of the contract, then material adverse effect is going to come into play. As opposed to, like I said, act of God, where it will come into play once the fulfillment of the obligations have started, or once the performance as agreed upon the contract has been started. Like, for example, let me give you a simple example for this. Let's say that I sign a contract, I am A, and I sign a contract with company B. All right. And I say that, on the 1st of January, I sign the contract and I tell them that I'm going to be starting my job. The performance of my functions, of my duties, of my responsibilities under the contract, let's say, will start from the 1st of March. Okay. And I sign a contract with the company B on the 1st of January. Now, if something happens between the 1st of January and the 1st of March, which is the time where, again, I have yet not started the performances as detailed in the contract, I have not yet started fulfilling the obligations as detailed in the contract. And if something happens where it becomes impossible for me to, start the function, start the performance from the 1st of March, then MAE will come into play. On the contrary, I sign the contract on 1st of Jan. I tell them I'm going to start working from the 1st of March. I join the work from 1st of March, and on the 30th of March, okay, on the 30th of March, something happens wherein it becomes impossible for me. It becomes impossible for me to fulfill my obligations, to perform my duties, to kind of, fulfill my responsibilities. Then act of God or force majeure will come into play. So I hope you were able to understand the distinction between the two. Okay. 1st January, I say I'm going to start the fulfillment of the contractual obligations from 1st of March. Yet not started, but sign the contract. Something happens in this period between 1st Jan and 1st March, MAC. I start the performances under the contract from the 1st of March. Something happens on the 30th of March or the 5th of April. And it is impossible for me to fulfill my obligations. This, in all probability, will be covered by the force majeure act of God clause. Okay. So this is the difference between MAC and force majeure. And now, coming to the questions. Okay. Coming to the questions quickly. Now, starting with the first question. All right, so let's now come to the first question here, guys. So the first question here says, based on the author's argument in the passage above, which of the following is correct? Okay. Now the first point, let us eliminate each option one by one. Option 1 says force majeure clauses generally have a uniform impact on the performance of the contracts in all cases. B says the impact on the performance of contracts by the usage of force majeure is dependent upon the way such clauses have been constructed. C says both force majeure and MAC clauses have similar impact on the performance. And D says all of the above. All right. Now the answer to this question, of course, lies in the passage only, guys. Okay. Now, if you start reading the passage from this point onwards, all right, what does it say? Certain contracts may state that if a force majeure clause is applied, the contract may be automatically terminated. So that is the first thing that force majeure can do. On the other hand, some contracts may even state that the duty to fulfill the contractual obligation may be suspended for a certain period of time. So what does this point tell us, guys? Now, in direct contradiction to option A, all right, in direct contradiction to option A, guys, option A says force majeure clauses generally have a uniform impact. I think that is definitely not true as per the passage, guys, because like we looked at the passage, it can have multiple implications. So it can have one implication, which is the contract is terminated automatically, and it can have another implication that the contract, permanently terminated, or the contract may be suspended for a brief period of time. Again, to give you an example, let's say A and B enter into a contract. Okay, A starts his performance under the contract. Now, after A starts his performance under the contract, let us say that there is an earthquake because of which A is severely injured. Now, now that he is not able to perform his part of the contract, the clause can be that the contract is terminated. Well, the contract is no more terminated. Or the clause can also say that for the time being that you are injured and you don't recover, then for that time period the contract will be suspended. But once you are in good health, once you're in the pink of health, then we will resume the contract. So it can be anything. It can be permanently terminated or it can be suspended for a brief period of time. Okay, which is why option A is ruled out. Okay, the correct answer, of course, for this question is B. Coming to point number 3, guys, this says both force majeure and MAC clauses have similar impact. Now, at the very onset of the class, I told you the distinction between MAC and force majeure. MAC will be applicable before the contract starts, before the performances under the contract starts, and force majeure in all probability while the contract is ongoing. All right. So the key word here for you to remember is before will be applicable to MAC, and another keyword here would be ongoing would be applicable to force majeure. All right. So obviously they don't have a similar impact, which is very clear, and which is why option C is also ruled out. All of the above by default gets ruled out, and which is why we are left with option B, which is the correct answer. Okay. So this part of the passage where I told you that there can be different implications, in a way gives the right answer to be B, and in a way also rules out option A. So that part that I just talked about in the passage, if you remember, that tells us both the fact that A is wrong and B is correct. Okay. Moving on to the next question. All right. So question number 68 says, imagine there is a domestic commercial contract for a supply of certain goods for certain price between A and B. However, in pursuance of the same, both A and B forget to negotiate and agree on the terms of a force majeure event, and the contractual document does not contain the FM clause. What would be the fate of the contract in the event like that of COVID-19? All right. Now, again, option A says, as the parties did not negotiate on FM, either of them cannot take an exception. Okay, sounds like a good option. Then B says parties can invoke the MAC clause. Okay. In the absence of such, the courts may resort to the applicable law. All right. Now, if you come to the passage, guys, this area has again been addressed in the passage itself. If you come to the last 3 lines of the passage, okay. So starting from this point, though there cannot be a one-size-fits-all solution to this question, and it depends upon how the force majeure clause is worded in a specific contract and now, and in the absence of the same. All right. So this is the point that addresses our question number 2. And in the absence of the same, applicable laws related to the same will be required to be taken into consideration. All right. So the passage nowhere says, I mean, it does advise that parties must obviously enter into a, have a force majeure clause in place. But if that force majeure clause is absent, the fact that now neither of them can resort to force majeure is not mentioned in the passage, which is why option A can be ruled out. All right. Now, coming to the next option, which says that MAC can be invoked, again, nothing in the passage. Nothing in the passage says that if force majeure is not a part of the contract, then MAC can be invoked. And anyway, MAC is a different concept altogether. Once the contract starts, once the contract is ongoing, then anyway, in a way, MAC will lose its significance. All right. So that second option again makes no sense. Now coming to the third option, guys, which says that applicable laws, Okay, if you come to the third option which says applicable laws, the courts may resort to the applicable law. I think that is exactly what has been mentioned in the passage here. You know, yes, that is exactly what has been mentioned in the last two lines of the passage, which makes C the correct answer for this question. Now, one more question that I kind of got from some of the kids when I was having the discussion of the paper in my classes was that, sir, the applicable law is the Indian Contract Act of 1872. All right. Now, if you go into the passage, now if we go back to the passage, guys, the problem is that in the entire passage, the Indian Contract Act is not really being talked about. Okay? I mean, they explain MAC, they explain everything, and even the last line says that the laws related to the same will be required to be taken into consideration. So, that law related to the same, whether it's the Indian Contract Act or not, is again something that has not been explicitly, or rather to say expressly, mentioned in the passage. And which is why there were people who also asked me, sir, that can none of the above be the correct answer? Because we really don't have anything in the passage. It only says applicable laws must be, applicable laws related to the same must be applied, but it doesn't really say the Contract Act of 1872 is the applicable law. And which is why some of the students did mark none of the above as the correct answer. I wouldn't say that their logic is completely incorrect. Look, the applicable law, yes, amongst other, definitely has to be Indian Contract Act, because it's at the end of the day a contract, and you know the the passage talks about contract. So Indian Contract Act is definitely an applicable law. But since it's not mentioned, and since we always tell students that something that is not a part of the passage should not really be considered as an answer, as an option choice, some of the students did mark none of the above, and I wouldn't say that it's completely incorrect. But the official correct answer for this question was option C, which again I will not say that it's incorrect. Okay, maybe it's a close call between C and D, but like I said, the official answer was C, and I don't think if the question would have been sent for scrutiny or for revision, the consortium would have really changed the answer, because there are enough points. Okay, there are enough reasons for them to justify C as the correct answer. Although, like I said, D cannot be ruled out completely. Okay, so if you did mark D while you were practicing this paper and you got it wrong, well, bad luck. I feel bad for you. But then, that's some of these answers in the CLAT paper, you do have to take them with a pinch of salt. All right. Moving on to the next question, guys. Moving on to the next question. The next question in the paper, the 69th question, okay? So the 69th question says, in the same fact situation as mentioned above with the modification that there is a force majeure clause between A and B, let us suppose that B, who was to supply goods to A on a certain date and time, faced issues in relation to procurement of goods due to mill strike, okay? Now this is important here. Whatever happened due to the mill strike. Okay, I don't know who changed the size of the marker pen. I don't know why is it so bold, but anyway, let's continue, because I'm technically handicapped and I don't know how to redo the changes. Anyway, all right. Now, yes, B, depending upon the way force majeure clause is worded, such situations cannot be covered under FM, as it is just a case of disappointed expectations, and hence B cannot invoke the clause. It is merely a case of commercial hardship. Okay, and B can invoke the force majeure clause as the clause is too broad to cover such situations. Okay, now I think this question is again pretty simple, guys. If you already have the answer key with you, then B was the official correct answer that was given, and I pretty much agree with this answer as well. So force majeure would be act of God, and if you, all right, okay, my writing is pretty terrible, please don't mind. Now, mill strike, all right, mill strike is what caused the breach of contract. Mill strike would be a natural phenomena or a man-made one. All right. Now, clearly the answer is that it's going to be a man-made phenomena, not natural, and which is why the FM clause is not going to be applicable in this case. So, which is why option 1 is ruled out. B can invoke the force majeure as the clause is too broad to cover such situations. The passage doesn't warrant anything like that. The passage doesn't say that it can cover broad situations like this one as well. Okay. Just give me one second. All right, the passage doesn't say that something like this, a commercial hardship would also be covered under act of God or force majeure, which pretty much leaves us with option B as the best answer. Although, I mean, I just felt that they didn't really need to add the disappointed expectations point. Some people started getting confused. They felt that the option is a very loose option. Okay, it's like a very emotional or a very sentimental option when they talked about disappointed expectations. But nonetheless, it is merely a case of commercial hardship is a very valid point. It is commercial hardship. Now, because of commercial hardship, that's what I'm saying. That, the contract becoming frustrated because of commercial hardship will not be the same thing as the contract becoming frustrated because of force majeure or act of God. Okay, so there's a difference. And again, that is something that I have been telling my students a lot of times, that just because now nobody says, I'm not saying that the contract is definitely valid. It can become frustrated. The only thing is that it will not be frustrated because of the reason that's being talked about in the passage. Okay, you need to understand the difference between the two. Nobody says that there's nothing wrong. Maybe it can be frustrated, but will it be frustrated because of the reason that's being talked about in the passage? Possibly not. Okay, or maybe not. And which is why the correct answer for this question is going to be option B. All right. Moving on to the next question. Typically, the MAE provision, okay, you can read this. This is question number 70, guys. Now, if we have to basically eliminate all the options, because the correct answer for this question is option D. All right, the official correct answer. A says, in the event of either party is unable to perform its obligation in the terms of this agreement because of act of God, strikes, equipment of transmission failure, or damage reasonably beyond its control, such party shall not be liable for damages to the other party. So this is, again, if you look at the entire thing, guys, it talks about act of God, and most importantly, it talks about events while the contract is ongoing. All right, this is important. Talks about events while the contract is ongoing. Moving on to the second point, except with respect to payment obligation, no party shall be liable for, nor such party will be injured due to any failure to perform as a result of causes including any earthquake, labor problem, unavailability of supplies, blah blah blah. Again, if you come to point number 2, again, guys, this is talking about problems that can arise in an ongoing contract. Okay, so since both of these pretty much talk about problems that can arise in an ongoing contract, I think none of the above or option D will be the best answer for this question as well. Okay, so this was question number 70th. All right, so this was the first passage of the paper, guys. This was the first passage of the paper. And now I would also quickly like to discuss one more passage with you. So the second passage that I basically talked about at the very onset of the class was the Tort Law Passage. So let me come to the Tort Law Passage. I will have another YouTube session where I'm going to discuss the remainder questions, but in 1 hour, I don't think we will be able to cross more than 2 questions. Okay, so the next question. All right, so let's come to this question, guys. Okay, so this is the next question that I would want to discuss. On the 7th May 2020, a major leakage. This is the question that I'm talking about now. Now, this question, again, like I told you, the paper was based on, current events. So in the beginning of the pandemic, we did have the LG polymer factory leak case, and majority of these pollution cases are dealt under tort law under the rule of strict liability and absolute liability. I hope everybody kind of has some idea about the strict liability and the, uh, all right. So I can see some of your comments as well here. All right, but I'll try to get back to the comments maybe later. Okay. Now, principle of strict liability and absolute liability, guys, again, I hope that you people have some idea about it. Okay. Now, both the two common things with strict liability and absolute liability is that what is required. Number one, that there must be a dangerous object. All right, that is one requirement. Second requirement is that the dangerous object must escape. All right. Uh, the third object may also be a non-natural use of land. All right. Okay. Now these are the three major requirements. You must store some dangerous object. Okay. That dangerous object must escape, and it must also be a non-natural use of the land. Okay. So those are the requirements. However, the only difference, all right, so if you can see, Ryland versus Fletcher is the landmark case where this rule was laid down. I mean, majority of you must also remember the facts where the person builds a water reservoir and the water escapes and causes some damage to the other person's property, and which is where the Rylands versus Fletcher case laid down the rule of strict liability, where the court held that any person who uses unnatural manner, okay, so this is the non-natural use of land, and who keeps any dangerous hazardous substance would be held liable under the principle of strict liability if the dangerous object escapes. Okay. Now the only difference, like I said, between absolute and strict liability is this part. Okay. So as you all know that there are certain defenses available to strict liability, and what are these defenses? The person is liable only when there is a non-natural user. The principle also restricts liability when escape is due to an act of strangers, act of God, for example, a natural calamity due to the person injured, or when it happens with the consent. Okay, so there are a few defenses. There are a few defenses which are available for strict liability, like act of strangers, plaintiff is the wrongdoer, act of God, consent, so on and so forth. But when it comes to absolute liability, okay, now if I come to absolute liability, the requirements are pretty much the same, but there are no exceptions. Okay, so absolute liability is a stringent form of strict liability. It is devoid of any exceptions. Okay, so that is the important. Pretty much the requirements. Okay, when you talk about the requirements, then absolute plus strict pretty much have the same requirement. The only big difference is that absolute has no exceptions. Okay, this comes with exceptions, but absolute liability has no exceptions. For the first time laid down in which case? MC Mehta versus Union of India. Whenever an enterprise engaged in any dangerous or hazardous activity that threatens the working of the people nearby, it was an absolute and non-delegable duty to the community that no harm will be caused. If harm is indeed caused, the enterprise will have to compensate and can't use exceptions provided in the case of strict liability. All right. So again, the only difference between the two, the last line also says the enterprise can't claim the harm has not been caused due to the negligence. So this is again something that you can't use, that I was not negligent or I tried to do everything, with the best of knowledge that no harm will be caused, but it still or it yet occurred. These are things that you basically cannot use as an exception. All right. So pretty much similar requirements, but strict comes with exceptions. Absolute doesn't come with any exception. And then there is the polluter pays, which is a rule that says that, again, pretty much similar to absolute liability in what way? The principle explicitly confirms that the person who damages or destroys the environment has the absolute obligation. Okay. So again, you see the word here, absolute. Absolute obligation would mean again what? That there will be no exceptions. All right. So what is the two things common between the rule of absolute liability and the rule of polluter pays? Both say that the liability under both of them will be absolute, which basically means that no exceptions are gonna be applicable to both these principles. Okay. Now coming to the questions that are based on this point. Let us quickly start with question number. All right. the first question, which is the 76th question. All right. Under which of the following will the company LG Polymers be liable? So this is question number 76. Polluter pays. Has it caused pollution to the environment? Yes, it has caused pollution to the environment. Strict liability, dangerous substance which escaped. Yes. Absolute liability, was this activity hazardous? Yes. And it was an absolute and non-delegable due to the community. No harm will be caused. Was harm caused? If harm is indeed caused, yes, it was caused, and therefore this is also applicable. And the correct answer, therefore, for this question becomes D for Delhi. All right. So this, I think, was pretty simple. Moving on to 77, as per the polluter pays principle, LG will be liable to pay amount of money restoration for environment, for restoration of environment, compensation to individuals, or only compensation to the victims. Okay, so now there are three things classified: only only the harm to the environment caused, only the victims who were affected, or both. Okay, I think this is very simple here. In Enviro Legal Action versus UI, the Apex Court of India held that the polluter is legally responsible to reimburse the individual sufferers, point number one, as well as pay for the revitalization of the damaged environment. Okay, so both victims plus environment is covered under the polluter's pay principle. All right, and if both is covered, then what would be the best answer for the question? B for Bombay becomes the best option for this question. All right, I think this was pretty simple. Moving on to question number 78. Okay. ABC Company Limited operates an industrial chemical plant in the city of Azadnagar. Due to an earthquake, the walls of the reactor in the plant get damaged, due to which blah blah blah, hazardous gas chemical vaporization resulting in gas leakage, death of 12 workers on the plant, and also some people living nearby. Okay, now in this question again, guys, for question number 78, we have to see under what all rules will these people, ABC Limited, be held liable. Okay, now ABC Limited can be held liable under the principles of strict and absolute liable and polluter pays as well. Okay. Now here if you see, guys, why did the leakage happen? Due to an earthquake. Okay. Now earthquake, of course, will be act of God. All right. Would earthquake be an act of God? Yes, it would be. All right. Now moving on to all the principles, guys. Again, would act of God have any impact on absolute liability rule? Was the damage caused? Hazardous use? Yes. Are there any exceptions? No. So would this earthquake have any impact on the absolute liability rule? No. Then coming to polluter pays. Okay. Again, if we come to polluter pays, guys, polluter pays again says that there is an absolute obligation. So again, act of God, will it have any impact on polluter pays? No. And then finally moving on to strict liability, here there is an exception that restricts liability when the escape is due to an act of God, for example, a natural calamity. Okay, is earthquake one? Of course, yes. So yes, this person, this company will not be held liable under the rule of maybe strict liability. Okay, so strict liability में ये बच जाएंगे. Absolute liability और polluter space के principle के हिसाब से obviously they would not be saved, and which is why the best answer for this question is can be held liable under polluter pays and absolute liability, but can be exempted under strict liability. Okay, so for this question, B for Bombay becomes the best answer. All right. Moving on to the next question, which is question 79. The argument of LG Polymers that they did not know that the styrene gas could leak. Like we have already discussed, guys, this is a very weak argument and will not help in reducing the liability under any of the principles. Okay, now remember guys, be it absolute liability, be it strict liability, or be it polluter pays, the fact that you say that we were not negligent, all right, the fact that you say that you were not negligent, or the fact that you say that you took care, will have no impact on either of these three things. For absolute liability, it is categorically mentioned, and even when it is not mentioned for SL and PP, obviously the idea here is that it's not given as an exception. So if it's not given as an exception, then what does it mean? That it is not going to matter. The fact that you say that I was not negligent or I took care is not going to matter for any of these three rules. For strict liability, certain things will matter. Certain things being what? Act of God will matter. Plaintiff is the wrongdoer is going to matter. But you were not negligent. Is that mentioned as an exception as well? No. And so is not. So this is the same thing is also not mentioned for polluter pays, which is why this is definitely going to be a weak argument. And C for Calcutta would be the best answer for this question. Okay. Moving on to question 80th. XYZ company is operating a pesticide factory in the city of Rampur. On one day, due to the negligence of factory staff, there is a leakage of the pesticide gas, as a result of which many pests and insects which feed on the plantation crops in the nearby farm are killed. There is no harm caused to the people living nearby or the workers. All right. So harm was caused to pests. Okay. However, the leakage reduced the quality of air, breathing problems for the people living in and around in the area. All right. Now, question number 80th, guy. If we come to all the three rules, none of the rule basically talks about damages in case of anybody apart from human beings is harmed. So what is going to be the liability under absolute or strict liability cannot be made certain, cannot be made clear. However, that said, there is clearly some damage to the environment in this case. And since there is a damage to the environment, the principle or the rule that may be invoked, or in fact that will be invoked, will be the polluter pays principle. All right. And so the best answer for question number 80 would be XYZ's liability and the strict and the absolute liability will depend upon the inquiry as to whether the leaked pesticide gas was a hazardous substance, activity, or chemical or not, and XYZ would be liable under the polluter pays principle. All right. So here, if you see, we haven't really been told if this gas was also kind of detrimental to the health of human beings. All right. Now, inquiry, because quality of air was reduced, causing breathing problems. Now, I mean, this is something which is not sufficient. There is clearly some data which is missing in this passage to conclusively say that the factory was hazardous use of land and the escape that happened actually caused, some problems to the human beings, because all that is said here, confirmed said here, is that insects in the nearby farm are kind of killed. Okay. So will depend on the inquiry as to whether leak gas was a hazardous substance or chemical or not. Again, is a very valid point to make here. And the one thing which definitely is clear is that the leakage was so humongous that it reduced the quality of air in the city. So what we can conclude is that some harm or some damage to the environment was definitely caused, and which is why for question number 80, the official answer that we got that year was C for Calcutta, and also in a way does seem to be the best answer for the question. All right. So human beings, again missing, whether the gas was hazardous or the use of land was non-natural, not clear. C seems to be the best answer for this question. Okay. All right. So I think our time is pretty much up, guys. And these were the two questions, that I wanted to discuss with you. I will very soon also schedule another YouTube session where I'm going to be discussing the remainder questions of this paper, and maybe a session later as well where I can also discuss with you the CLAT 2021 paper that I think might take a little bit more time because the passages were very complex and convoluted and heavily worded and quite verbose in nature, to be frank. So drop your comments in the comments box if you have any questions, which I will perhaps get back to you later. And happy prepping for the CLAT paper, guys. All the best. Bye, all of you. Bye.